I will speak today about the arbitral proceedings at the SCC in accordance with the SCC rules, a little bit about practical matters. I will provide you with some statistics and figures from last year and generally on operations of the SCC. I'll try to answer your questions as to who does what at the Institute. It's also an interesting and important question for you who are practicing lawyers. All institutions are different and have different structures. And then we will go through the SCC procedures in accordance with the SCC rules in the focus. And in the end, I will say a few words about the SCC's expedited rules. I hope that we will have a discussion here. And I know that some of you have had experience of arbitrating disputes at the SCC. It would be very good to have your feedback and if you share your experiences and comments with all of us. To start with a few words about the historical background of the SCC, it's one of the eldest organizations, arbitration institutions in the world. It's 3 years ago, it turned 100 years old, and it was established as a service of the Stockholm Chamber of Commerce. At the very beginning, it was a service primarily for the companies and businesses in the Stockholm region, but with years, it grew up into an internationally recognized institution. Today, the SCC handles about 150 to 200 cases per year. The caseload is not the biggest one in the world, but it's very diverse and very interesting because half of the SCC's cases are international cases, and most of them have no connection to Sweden at all, apart from the seat of arbitration and application of the SCC rules. Otherwise, the parties come from different jurisdictions. The SCC is also known for its caseload related to so-called East-West disputes coming from CIS countries, that is Russia, Kazakhstan, Ukraine, and so on, Eastern Europe and Asia. And on a yearly basis, we do see quite a lot of such disputes. Also, energy-related disputes related to either investments into energy sectors, and those disputes can be both investment disputes and also commercial disputes. And disputes related to deliveries of oil, gas, equipment for construction of pipelines, and similar. The SCC is also taken into quite a lot of bilateral investment treaties as a forum for dispute resolution, and therefore we do see investment disputes under the SCC rules here in our caseload. Currently, as far as we know, the SCC is the forum for investor-state dispute resolution in approximately 120 bilateral investment treaties and also in the Energy Charter Treaty. And here are some figures from the past year, 2019, the nationality of the parties, as you can see here. Parties are coming from quite a lot of countries. Approximately 45 countries are represented on our caseload regularly. And the statistics usually looks more or less the same every year in terms of number of parties coming from Russia, almost always on the second place, after Swedish parties, Germany, United States, and the CIS countries, as I mentioned before. And time for rendering the award, it is quite an important parameter for the parties, for counsel representing them. Here you can see the statistics and the lengths of the proceedings under the SCC rules. Most of the cases are terminated by an award, 77% altogether within 12 months approximately. We also have, of course, more complex and big cases which take more time. Among them, investment cases, which normally take much longer time, approximately 3 to 5 years, from the beginning to the award. A few words about the SCC's organization. Arbitral institutions actually do look very different, and they have very different organizations, and unless you have a lot of experience of dealing with one or another institution, it might be difficult for you to understand who does what in the organization, who makes decisions, who can answer your questions. The SCC has quite a hierarchical structure. It consists of a secretariat with 3 departments who handle cases. Each department consists of a lawyer and an assistant. If you have a pending proceeding at the SCC, it's usually a lawyer or an assistant that you deal with if you have procedural questions or practical questions related to administration of the case. Decisions, most of the decisions are taken by the SCC board. The board consists of currently 16 members, of which 7 members are Swedish experts in arbitration and 9 international members. The board is appointed by the Stockholm Chamber of Commerce board, and the board actually, they are not employed by the SCC. They are external members and external experts in arbitration. We meet every month with the board over phone conference or in person, when it was possible to meet in person, of course, and discuss cases. The board takes decisions on certain issues which are outlined in the SCC rules, such as prima facie jurisdiction, appointment of arbitrators, challenges to arbitrators, and some other decisions. So this is the structure of the SCC, the board and the secretariat, and of course arbitrators. Who are arbitrators? They again are not employed by the SCC, neither by the Stockholm Chamber of Commerce. They are external specialists in arbitration. They might be working with law firms, they might be professors, academia, and they are appointed by decision of the board. They act in every specific case, in each specific case where they appointed. The SCC does not have any roster or list of arbitrators, and this is also a special feature of the SCC's organization. And the parties are free to appoint any arbitrator of their choice, subject to impartiality and independence requirements. And I will talk a little bit about that later during my presentation. Also about the selection process. I mentioned already the structure, and here you can see a few bullets concerning who does what at the SCC. I mentioned already that the secretariat is involved into daily operations. We work with cases, and we also have some other types of tasks, such as, for instance, organizing and conducting conferences and webinars, and speaking about on various topics related to international arbitrations. We also write quite a lot of articles and publish quite a lot of materials on our websites and also on external portals. A few words about the SCC rules. It's good to know that the SCC has several rules. The most used ones are the SCC arbitration rules, the standard procedure of arbitration, and you will see like a majority of the cases under the SCC rules in our statistics. However, expedited rules are also applied in some cases by agreement of the parties. So in order to run an expedited procedure in a case, we need the consent of both parties, either through the arbitration clause where they simply state that the case, the dispute will be resolved under the SCC expedited proceedings, or in the course of exchange of briefs at the initial stage of the proceedings. I will speak a little bit later also about the differences between the standard SCC rules and expedited rules. Both sets of rules, the standard and expedited, have provisions on emergency arbitration. Emergency arbitration provisions are actually part of the rules, and they handle about appointment of emergency arbitrator to decide on urgent interim relief before the initiation of the main proceedings, sometimes in the course of the main proceedings, but always before the main tribunal is appointed. So this is the stage where a party can request appointment of emergency arbitrator. The SCC also assists in ad hoc proceedings as appointing authority, as an authority deciding on challenges to arbitral tribunals, and also we can render certain services to arbitral tribunals, such as record keeping and fund holding. Mediations. The SCC has also mediation rules, but in Sweden mediation is not really popular, and normally we do not have more than 1 or 2 cases per year under the SCC mediation rules. Yes, so I have just given you a short outline about which rules we have. And here you can see a chart over the proceedings from the beginning to the end, how it looks like. It's quite typical for institutional arbitration. We have 2 stages in the proceedings. The first one is the initial stage of arbitration, when the case is handled by the institute, by the secretariat, and when the arbitral tribunal is not appointed or has not been yet appointed. And the purpose of that stage actually is to define the procedural framework of arbitration, to appoint the tribunal, to clarify any procedural issues which fall within the powers of the SCC board, such as prima facie jurisdiction, advance on cost. It's an administrative but very important question. It is also collected at the beginning of the proceedings during the first 3 to 4 weeks of the arbitration at the SCC. And this initial stage actually consists of 2 briefs or exchange of briefs between the claimant and respondent, request for arbitration and answer to the request for arbitration. Sometimes claimant is also given a possibility to comment on the request for arbitration if the secretariat deems it necessary from the point of view of some unclear issues. It might be jurisdiction, it might be counterclaims, or anything else. And once this preliminary stage is over, and it is normally over when we have the request for arbitration, the answer, the tribunal is appointed, and the advance on cost is collected by the secretariat, then the case is referred to the arbitral tribunal. And from the date of the referral, the tribunal has 6 months under the standard arbitration rules to render the award. That term sometimes is extended in quite a lot of cases, actually, most often because the parties and the tribunal agree on a schedule of the proceedings which stretches beyond these 6 months term. And the proceeding normally looks like as following. As soon as the tribunal gets the file of the case, they call the parties to the case management conference. As a rule, it's a phone conference, or it can be a video conference, and agree on the schedule of the proceedings, some household matters, and hear the parties' comments as to how many rounds of exchange of briefs the parties wish to have, which stages of the proceedings they request, whether they request a hearing, whether they want the examination of the case to be on documents. And the case management conference is followed by the first procedural order and established schedule of the proceedings. And then, following that schedule of the proceedings, the parties present their case, meet with the tribunal for a hearing, and there might be also post-hearing briefs, rejoinders, cost statements after the hearing, and then the award. As a rule, as I mentioned before, the whole proceedings takes around 12 months from the very first day when we receive the request for arbitration up to the award. There is a short stage even after the award, when the Secretariat again enters the scene of the proceedings and informs the parties of the accounts, the settlement of accounts. Because normally when we receive advances on costs, the advance is a little bit bigger than the cost, the factual cost of arbitration, because we normally calculate some additional amounts which are supposed to cover the cost of the traveling of the tribunal or anything else in connection with the hearings. And if there was no hearing or the tribunal did not have to travel, then these exceeding amounts are returned back to the parties in the same proportion as the advance was paid in the beginning. The advance is paid 50-50 by the parties, unless the board decides that separate advances apply. That decision is taken in certain circumstances upon request of a party. But the main rule is 50-50, and the whole advance is paid up front in the beginning of the arbitration. It is supposed to cover the whole proceedings. Sometimes it is indeed adjusted in the middle of the proceedings, and those are the cases where claims go up or down, or there are any other factors influencing the cost of arbitration, such as complexity of the case, bifurcation of the proceedings, additional stages in the proceedings, making the case more complicated than expected from the beginning. The award is normally circulated by the tribunal and in the original, not by the Secretariat, but the Secretariat always requests the award on paper. The whole document flow at the SCC is actually electronic. What we usually have on paper is the request for arbitration, which we notify through all our channels, that is by post, by email, through the platform, and also the original award. That one we also need on paper in the original with original signatures. Now, let me say a few words about the request for arbitration, the document by which a party initiates the arbitral proceedings. I think that there are similar provisions in many institutions actually in the world, but it may also differ in some institutions, and this is also typical for Eastern European institutions. The proceedings, arbitral proceedings, may begin with a statement of claim, while at the SCC, the proceedings begin with the request for arbitration. The rules actually list what the request should include, and all the requirements might be found in Article 6 of the rules. I'm not going to read them here. You can acquaint yourself with this provision of the rules. However, it's good to remember that we ask the parties to be specific about the ground for their request for arbitration and the ground for the initiation of arbitration. That is, the arbitration agreement, the arbitration clause should be included into the request for arbitration, preferably also the disputed contract, because it is always needed, of course, in the course of the proceedings. So it's good to submit the disputed contract already at the outset, together with the request for arbitration. It is also important to, if you seek, for instance, a declaratory relief, to make an estimate of the disputed value anyway, and this is also a requirement of the rules. We need this in order to assess the advance on costs and to establish the advance on costs, because at the SCC, as in many other institutions, the advance on costs and the costs themselves are related to the disputed amount. This is so-called ad valorem system. If you make a request for arbitration, if you file a request for arbitration based on several contracts, then you should specify which claim is based on which contract. This is also important to know. So in this respect, the request for arbitration should be very specific. Then here you can see that if you make request for joinder, and the joinder request actually normally is submitted by respondent party, and this is also good to remember, then there is quite clear deadline under the SCC rules that request should be presented at the very beginning of the proceedings, at the latest in the answer to the request for arbitration. So if you want to take in a third party, another party to the current proceeding, then such request should be presented not later than your answer to the request for arbitration. An important part of the initial stage in the proceedings is formation of the arbitral tribunal. And here you can see a few requirements on arbitrators under the SCC rules and the Swedish arbitration law. Well, the requirements are quite similar, I guess, to many other arbitration laws around the world. Arbitral tribunal, and this is explicitly stated in the Swedish Arbitration Act, not in the rules, must have full legal capacity, that is, be over 18 years and should not be in personal bankruptcy proceedings. And then impartiality and independence requirement. This requirement is, of course, entirely in accordance with the requirements of, for instance, the model ancestral arbitration rules and the model law. So in this respect, it's not in any way different. Good to remember that the rules do not indicate any default number of arbitrators to be appointed in a dispute. Quite often parties actually agree how many arbitrators would decide on their dispute in the arbitration clause, but sometimes there is no such provision. The rules do not establish any default rules, neither 1 nor 3, and where there is no agreement between the parties and the arbitration clause does not say anything, then the number is determined by the SCC board, given the circumstances of the dispute. It might be the disputed amount, one of the factors which is taken into consideration, complexity of the dispute. This rule, however, the default rule on the number of arbitrators is actually present in the appendix to the SCC rules dealing with investment disputes. There you will see that the tribunal should consist of 3 arbitrators. This is simply because investment disputes are almost all of them are quite complicated, lengthy. They involve very complicated and highly specialized jurisprudence. And so from that perspective, a tribunal of 3 arbitrators is recommendable, and therefore there is such a default rule under the SCC rules dealing with investment disputes. Another interesting, yes, under the expedited rules, a sole arbitrator is always appointed. So it's part of expedited rules. It's a sole arbitrator, either jointly appointed by the parties or appointed by the SCC. Another interesting point that I wanted to bring your attention to is the requirement, or rather silence of the Swedish Arbitration Act as to the immunities or limitation of liability of arbitrators. In this respect, there is no such provision in the Swedish Arbitration Act, although you may have experience from other jurisdictions where you will find a similar provision. However, limitation of liability is included as a separate provision into the SCC rules, so you can find it there. As to the mechanism for appointment, the in the SCC proceedings, arbitrators, where we have a 3-member tribunal, are appointed by the parties. Each party appoints 1 arbitrator, and the chair of the tribunal, unless the parties agree otherwise, is appointed by the SCC board. So it's not the 2 co-arbitrators who appoint the chair, again, unless there is another agreement between the parties and the tribunal, but it's the board who appoints. The chair should be of a neutral nationality. There is such a provision in the SCC rules, meaning that the nationality of the chairperson should not be one of the nationality of the parties. I should also mention that there is a special mechanism for appointment of tribunal in multi-party arbitrations, which requires that multiple claimants or multiple respondents should be in agreement about the appointment of arbitrator. If one of the sides disagree, then the whole tribunal is appointed by the SCC board. And where arbitrators are appointed, there is always, of course, a possibility to challenge an arbitrator if there is a ground for such a challenge, such as doubts in arbitrators' impartiality and independence. Challenges can be, well, filed anytime in the proceedings until the award is given. After the award, a party cannot challenge an arbitrator, but a party can challenge the award itself, invoking impartiality and independence issues. But then that will be a separate stage. It's not an arbitral stage, but it's post-arbitration stage in court. Under the Swedish Arbitration Act, Section 8, an arbitrator might be challenged within 15 days, as from the moment the parties becomes aware of the circumstance that raises doubts in arbitrators' impartiality and independence. The same time applies under the SCC rules, 15 days. And the SCC has a strong practice of application of objective criteria for assessment of impartiality and independence issues from the point of view of a third reasonable person. We do rely to some extent on IBA guidelines on the conflict of interest in international arbitration, but we also have our own practice, which is also published regularly on our website in anonymized summaries. The decisions on challenges to arbitrators are provided with reasons, and we started give reasons as from 2018, I think, and the whole idea of giving reasons is to make the decision transparent and clear for the parties. So the board provides reasons which are sent either together with the decision itself or sometimes after, in order to expedite the proceedings. But normally reasons come very soon after the decision is communicated to the parties. Once the tribunal gets the file of the case, they also have to ensure that the proceedings are handled efficiently and expeditiously, of course, and therefore we have the provisions on schedule of the proceedings. We monitor the proceedings from the side of the Secretariat, request tribunals to get back with updates and concerning the, for instance, submission of certain briefs by the parties. And also tribunal has to revert to the SCC when the proceedings are coming to the end with a summary and a short report on what has been done by the tribunal. And that report becomes a ground for establishing the tribunal's final fees in the end of the arbitration. And the tribunal itself can also attach attention and importance to parties' behavior in arbitration, whether the parties acted expeditiously and efficiently in the proceedings, and decide on costs, having regard to these factors. Also, of course, the main factor is the outcome of the proceedings, but the parties' behavior and the parties' procedural expeditiousness also plays role. But the SCC, when establishing the fees of the tribunal, also takes into consideration whether the tribunal itself was efficient enough in handling the case. So this is also an important factor for the cost, overall cost of the arbitration. I would like to say a few words about summary procedure. That is a new provision that was introduced into the SCC rules in 2017. It's a new mechanism by which a party, any party, at any stage of the proceedings may request a decision of the tribunal on certain particular and important issue in arbitration. And such decision, for instance, might be decisive for the whole proceeding. The proceeding, for instance, might stop after such decision because the decision might be rendered in the form of the award. In Article 39 of the SCC rules, you will see several criteria for the parties to file such an application. This may include an assertion that an allegation of fact or law material to the outcome of the case is, for instance, manifestly unsustainable, and even if the facts alleged by the other party are assumed to be true, no award could be rendered in favor of that party under the applicable rule, or any issue of fact or law material to the outcome of the case is suitable for determination by way of summary procedure. So the rule actually lists a few examples of situations when a party can request summary procedure. Out of our experience, I could say that sometimes actually parties confuse summary procedure and expedited rules. This is not the same. Summary procedure is a step in the arbitration itself by which arbitration can be actually decided if there is a material and important issue of law or fact. And another interesting development is that sometimes parties take summary procedure as kind of expedited procedure for the whole case, requesting already in the request for arbitration without highlighting which question actually they want to be decided by summary procedure, stating that all of our claims should be decided in summary procedure. And this is also not the purpose of summary procedure, to decide the whole case without the full extent of exchange of briefs, as it is provided by Article 39, for instance, in the SCC rules. The tribunal does not have any deadline for deciding on the issue of summary procedure, but this is actually determined, the deadline is determined by the tribunal itself. Another new provision that was introduced into the rules in 2017 is administrative secretary. Basically, that provision in Article 24 regulates the SCC's practice that actually existed before 2017, and it was simply codified in the rules, stating that there is a need for parties' approval for a specific secretary. The secretary should file a declaration of independence and impartiality, just as other members of the arbitral tribunal. The rule says that the secretary should deal only with administrative tasks, and the tribunal has to discuss the tasks of the secretary with the parties. And there is also a procedure for the removal of the secretary. And another interesting feature in the rules is that now we have a provision on security for costs. Parties can ask for security for costs during the proceedings, although such possibility on practice actually did exist even before 2017. But again, now there is an explicit rule on this. And there was a little gap in the rules before 2017, which did not regulate whether the emergency arbitrator can rule on the issue of allocation of costs in emergency proceedings. And that gap was filled in 2017 by introducing a special provision in the emergency arbitrator appendix to the rules. Well, so far I don't see whether we have any comments or questions. I guess that probably you will get back with your comments and questions in the end of the presentation, but otherwise please feel free, and please keep in mind that your microphones are not on. You have to switch them on. Cost of the arbitration. Here are,
Could we write?
yes.
Could we write our question? Write in. Could we write?
You can, if you have questions, you can write them in the chat.
Okay. Okay. Can I send it now? Can I send it now?
Otherwise, please feel free. You can also ask them as you like.
Okay. Okay. Thank you very much.
No problem. A few words about the costs of arbitration. Yeah, the cost of arbitration should be requested by the parties. This is a general rule and general concept that the tribunal awards what has been requested actually. The cost should be presented and specified in the final award. And this is actually a requirement of the Swedish Arbitration Act, but there is such a requirement of the rules as well. So there should be a specification, not an aggregate amount of all the fees, for instance, in the end of the award, but there should be a specification of the fees themselves and the cost of the tribunal. And another interesting feature, which is special for the Swedish Arbitration Act and for the Swedish court practice, is that arbitrators' fees might be challenged in courts. That is a general provision in the Act, paragraph 41, and parties have 2 months after rendering the award and when they see the fees of the arbitrators to file a challenge if they do this. On practice, this provision is applicable extremely rarely. Basically, the court practice in this respect is extremely limited, at least for the time being. I see here a couple of questions. Let me start with the first one from Mr. Larussi. The cost of arbitration is high, and Singapore Convention on International Settlement Agreement resulting from mediation will enter into force on 12 September. Do you think that the mediation will become a competitor of arbitration? Well, I don't think this will happen immediately, although of course mediation has a lot of advantages in terms of its flexibility. It's low cost as a rule. It's the cost is low in mediation. Its expeditiousness compared to arbitration. But again, still, as long as there is no developed practice for enforcement of mediation agreements, there is still a big issue how to enforce this, and I think that might become somehow a hinder so far for development of mediation. On a national level, mediation might be popular in those countries where mediation is mandated by law for certain kinds of disputes. I know that in Italy, for instance, this applies. In common law countries, mediation is much more popular than, for instance, in Sweden. In Sweden, there is a law on mediation, but still there is no tradition, unfortunately. Although we promote actually not only arbitration as dispute resolution method, but also other alternative dispute resolution methods, and we assist parties. But so far, we do not see any trend for increased popularity of mediation. I'm speaking only about Sweden so far. But hopefully, the Singapore Convention will become an important incentive for the parties for at least considering mediation as a dispute resolution method. Dmitry Marinkov asks question whether we often face pathological arbitration clauses. That was the case maybe 10 years ago, in particular in the SCC's CIS-related caseload, that is clauses coming from Russia, Kazakhstan, Ukraine, Azerbaijan, and other Commonwealth states. Most of the pathologies actually refer to the name of the arbitral institution, and some of them deal with the incorrect, like misunderstanding of what is institutional arbitration and what is ad hoc. Very often parties write into their arbitration clauses and ad hoc provisions stating that the arbitration will be conducted in accordance with the Swedish Arbitration Act and without any reference to the SCC or any other institution, and this is ad hoc. Although the parties do not have a slightest idea that this is actually that the request for arbitration should not be filed with an institution, they still come to institution. Sometimes pathologies have different nature. They can be like the seat of arbitration in Switzerland, Stockholm. So mixing up things, these ones are a little bit kind of a typo in an arbitration clause. Currently, we do not have that many pathological clauses, actually, and I would also say that pathologies are no longer as strong as we seen before. And I think that this is partially due to the to increased popularity of international arbitration and more knowledge about international arbitration on the level of particular jurisdictions. There are stronger arbitral communities almost everywhere in the world, strong institutional centers in many countries. So this also contributes into the knowledge about arbitration, and like parties are much more accurate nowadays in drafting the arbitration clauses. There is one more question. If the arbitrators are appointed by the SCC, since there is no list, what are the relevant criteria for the SCC to decide? Very good question, actually, how you choose arbitrators. We look into the facts of the case, applicable law, any language, particular language skills, which might be required if the case is handled in a different language than English, or for Swedish cases, Swedish. Then what kind of disputed contract is there in the ground of arbitration, and also we have a big database of arbitrators and generally experts in arbitration, those people who have ever participated in the SSA cases, and that database is searchable. We can see various experiences, and let's say the cases between I don't know, German and Russian party, the contract is drafted in German and Russian and the language is English, then we will of course try to find an arbitrator who would be proficient not only in English but at least in further languages such as Russian and German. Then we will look whether this requires any particular skills in handling the case. Sometimes cases are extremely complicated from the procedural point of view. For instance, the parties present a lot of objections such as jurisdiction, admissibility, a lot of challenges and everything. This requires certain experience in many other arbitrations, I would say, and management skills. So these are the criteria. I should also mention that apart from the other criteria, which are obvious, such as independence and impartiality, we run conflict checks and so on, there are also policy issues. We try to give way not only to experienced arbitrators, but also to young arbitrators who are aspiring to become specialists in international arbitrations, but who have already a good knowledge and who have appeared on several occasions as counsel and who generally seem to be skilled and appropriate for appointment. We also try to appoint equal number of female and male arbitrators, although in some branches this is not unfortunately possible, simply because there are no that many female names, let's say construction branch. Sometimes it's difficult to find a female arbitrator, but it's a part of the SCC's policy. Another question, how often do SCC arbitrations result in settlement, awards on agreed terms? Well, I would not give you specific, Dmitry, it's a question from Dmitry Marinkov. I will not give you specific figures as regards settlements and agreed terms. Sometimes settlement leads to withdrawal. without, like, we do not see the settlement terms in the proceedings and they are not established in the final awards. But generally, I would say that quite a big share of cases end up with settlement. I would dare to say that something like between 20 to 30% of them do not go to the award. But this does not concern all types of disputes. For instance, investment disputes are rarely settled. Then in international disputes, settlements are quite do happen, but in minor disputes, of course, they are less frequent. In minor disputes of certain kind with certain jurisdictions, respondents do not participate at all, then you will not see a settlement there. But yes, generally settlements do occur and do occur in quite a lot of cases, actually. Next question from Christian Arsovsky. Do you believe that multi-tie arbitration clauses would be options if parties would resort to more often in light of COVID situation? Is there any problem regarding the applicability, namely in view of Swedish case law? I don't know whether you refer to any specific case law, Swedish case law, then please let me know whether you have any special case in mind. But in the light of COVID situation, I think that, well, this situation occurred all of a sudden. It was not really expected. I do not think that there was any country in the world that was fully prepared for that situation. And the same goes for arbitrations. The only thing that can happen in pending cases now is that parties and tribunals would be more inclined to accept online solutions for their proceedings. A big part of arbitral proceedings, and I think the same could go to mediation, for instance, is already online. There is no need to do anything else apart from the hearing part. And I think the mediation is the same. In mediation, though, I would say that this is a little bit more difficult because in mediation, the interaction between the mediator and the parties is a little bit different than in a standard arbitration hearing, and there should be more interaction between mediator and each of the parties. So I don't know, we do not have that experience yet. And I would not give you any forecast for the future, apart from one thing that I want to point out, that irrespective of the outcome and the timeline of COVID situation, I think that the whole arbitral community, in order to make the whole branch sustainable, should opt for more online solutions, actually, and think a little bit more proactively in terms of conducting online hearing where this is possible. There are plenty of small cases where you do not need a hearing for 2 weeks. You can have a hearing in a half a day. So those can be without any witnesses or without experts or anything else, just parties presenting their positions. And the arbitral tribunal listening to them. Those cases might be very well suitable for online hearing, and then any COVID situation would not have any impact whatsoever. What are Dmitry Marinkov? By the way, everyone, many thanks for your questions. All of them are really interesting, and I'm happy that you are interacting. What are the most common nationalities of arbitrators in SCC proceedings, except for Swedish arbitrators? Well, I'm not sure whether we have these statistics on our website, actually, nationality, arbitrators by nationality. But I would say that nationalities are really diverse. Of course, in Swedish, purely domestic cases, you would in most situations see a Swedish arbitrator. In international cases, it is not the case that only Swedish arbitrators are appointed. Quite a lot of international arbitrators are appointed. I would say that we have quite a broad pool of arbitrators coming from common law jurisdictions, such as UK, might be some arbitrators from the United States. Then we do see quite often in the SCC cases as party-appointed arbitrators from Switzerland and also from Germany, from Italy, more and more appearing on our caseload, from other Scandinavian countries. Finnish arbitrators are very, very skilled generally and appointed quite often, both by parties and also by the SCC and many other nationalities. I see that Lise Alm has actually shared a slide from the SCC's statistics on our website, nationality of arbitrators, so in 2019. So you can get a much better idea probably here, but you see that the vast majority of arbitrators are actually coming from the European Union. Some are from the CIS, such as Russian arbitrators, Kazakhstan, Ukraine, and so on. Well, many thanks, Lisa, for sharing. It's very useful. Okay, I have only one slide left, actually. A few words about the SCC expedited rules, as I promised in the beginning of my presentation. The SCC expedited rules were first drafted and enacted in 1998, many, many years ago, provoking a lot of debates on the Swedish arbitration, in Swedish arbitration community, what that was and why, and what is the need for expedited proceeding. And that was really unusual that you would have a sole arbitrator. That was not usual that the default provision in an arbitral proceeding would be not to have a hearing, and the expedited rules actually do not provide for a hearing, although on practice we do see hearings in expedited proceedings quite often upon requests of the parties. Again, that is the idea of the expedited rules, to make the proceeding in certain types of disputes, and it follows from the name that like the disputes that are manageable within a short time period, make the proceeding faster and quicker. The expedited proceeding provides for front loading of the case, meaning that your request for arbitration should serve as a statement of claim and your answer as a statement of defense. And this means that in the beginning of the case, the claimant, the respondent party, would get a little bit longer time compared to the standard proceedings to reply. But that reply, that answer would be the statement of defense. So there is no need for additional several rounds of briefs. And those briefs that we refer to the sole arbitrator under the expedited rules would serve as a main basis for examination of the case. Although, again, on practice, parties agree and the tribunal order another exchange of briefs after the sole arbitrator gets the files. The sole arbitrator is given 3 months only to render the award in the expedited proceedings. And here I should also mention the following. Some parties have a tendency to request expedited proceedings in bigger disputes than those that the rules are actually much more suitable for. Disputes with high disputed value, by this meaning like more than €1 million, for instance, or disputes which are from the outset very complicated. You see there is a jurisdictional provision, a jurisdictional objection there. There are plenty of claims, multiple claims, several counterclaims. The disputed agreement is complicated, some construction with plenty of technicalities. And you can see from the outset that this dispute probably is not appropriate for an expedited proceeding, because parties request, let's say, examination and hearing with 20 witnesses from the beginning. So in such situations, we propose the parties to go over to the standard rules. We send a special letter proposing them, asking them to agree on rule swap. And again, we need an agreement from the parties to do that. If they do not agree, then we run an expedited proceedings, but then the parties are made aware that expedited proceedings have their limitations in accordance with the rules that are chosen by the parties. So it's good to keep in mind. And another thing is that if the case is a big one and the expedited proceedings actually would not be suitable, then the cost might be determined at the higher end of the table of costs. Of course, this would be like a natural decision. But again, we do not do anything against the agreement of the parties. If they do not agree to apply standard rules, then we do not apply them. And that was it. I thank you very much for your for listening, for joining our webinar today. Let me see. I'm checking now the chat whether there are any further questions. No, not so far. Well, then thank you very much for attending. We are still running our webinar program and webinar menu at the SCC. There will be more seminars and webinars in different languages until the end of May. I wish all of you to be healthy and stay safe, and I hope that we will soon be able to meet each other in person during conferences, networking meetings. But until then, thank you for attending this webinar. Thank you and goodbye.